Good day. My name is Adeshola Adekombi. I am a student of Anglo Ruskin University, London, and today I will be making a presentation for my land law module. The question for the presentation is, as the 2002 reform of the Land Registration Act sealed the crack in the mirror principle caused by overriding interest. I proceed. The system of land registration was formally introduced by the Land Registration Act 1925. Yet, prior to this, there was only a provision for voluntary registration of title of ownership by the legislation of the 1862. The aim of the LRA 1925 was to modernize the law and render the sale of land rapid, with the end result being the successful establishment of a title register. The LRA has three principles, namely the mirror principle, the insurance principle, and the curtain principle. But for the purpose of this presentation, I would only be discussing the mirror principle and the curtain principle. The mirror principle is the most important principle of the LRA. The idea behind this principle was for everything relating to a land to reflect in the register so that there are no surprises for the buyer. The mirror principle held that the register is a conclusive reflection of title ownership as well as the interest affecting the particular land. This principle depends on registration of all rights, and if there is a right that exists in the land that does not need to be registered, then the register does not give the accurate reflection of the title of such land. The curtain principle, on the other hand, puts the purchaser of land in a situation where they are not aware of the matters behind the entries of the register, and this matters such as trust affecting the land. These interests that are not visible on the register, but a purchaser of land will still be bound by them, and the purchaser needs to find if there is such rights or such interest in the land, which goes against the mirror principle. The terminology used to describe this situation is called the crack in the mirror principle, and such interests in land law are referred to as minor interests. The overriding interest of Section 70 of the LRA 1925 can be seen as minor interests as they are not visible on the register, and hence the crack the mirror principle. Overriding interests can be defined as interests to which a registered title is subject, even though they do not appear in the register. They are binding both on the registered proprietor and on the person who acquires an interest in the property. Overriding interests are recognized as the crack in the mirror and have always been seen as a major flaw in the operation of the land registration system. In LRA 1925, there were too many overriding interests under Section 70, which made it problematic. There is perhaps no other creation of the Land Registration Act of the 1925 that got as much first comment as Section 70 subsection 1 and its long list of overriding interests. The fact that there is a category of property rights that can bind the purchaser of a registered title without either that interest appearing on the register or necessarily being discoverable is thought by many to be contrary to the very idea of the registration system. The most obvious example of some of the interests under Section 70 is the right of equitable co-ownership stemming from the case of Petit and Petit, whose effect under Section 70 subsection 1G on an unwary purchaser was first fully appreciated in the case of Williams and Greensbank and Boland. Another is the equitable estoppel easement said to fall under Section 70 subsection 1A in the case of Silson and Houston, and also in the case of Ferriers Limited and Wallside, in which the plaintiff's overriding interest in respect of the property was undiscoverable because its actual occupation only extended to a certain part of that property. This difficulty concerning overriding interest is one of the many reasons why the Law Commission recommended a reduction in their scope, and this has now been implemented in Schedules 1 and Schedules 3 of the Land Registration Act 2002. The LRA 2002. In the year 1996, the Law Commission joined hands with Her Majesty's Land Registry to begin a program which would reform the process of land registration, with the motive being to update the Land Registration Act 1925. The aim of the LRA 2002 was that all essential information to a piece of land be held at the land registry, and every entry on the land register means that the information has satisfied all investigations without defect and they are therefore conclusive. The LRA 2002 was the first major reform of English land law since the Land Registration Act 1925. The introduction of electronic conveyancing was the essential driving force for property professionals and policymakers alike to agree towards a way in which land and the various interests in it were registered. A framework was developed to make the register of title as comprehensive and transparent as possible, to all purchasers of land feel at ease and to minimize the incidence of any undiscoverable interest of a third party binding the purchasers at a later stage. It therefore contains two separate lists which transforms overriding interest to interests that override. Schedule 1 lists those interests that override first registration, and they do so by virtue of Section 11 subsection 4 or Sections 12 subsection 4 of the Land Registration Act 2002, while Schedule 3 lists those that override registered disposition, and they do so by virtue of Sections 29 subsection 2 or Section 30 subsection 2 of the LRA 2002. When compared to the LRA 1925, the LRA 2002 reduces the scope and the range of overriding interest in respect of both Schedules 1 and 2. The aim is to ensure that a potential purchaser of the land is bound only by those unregistered interests which it is absolutely necessary must bind the buyer without registration. Under the new scheme, there are a number of deliberate omissions from both schedules. First, equitable easements no longer fall within either schedules, despite being overriding interest under the LRA 1925 after the case of Silston and Alton. Also, overriding status will no longer be accorded to the rights of person in receipts of rents and profits of the land, and subsequently, the rights of adverse possessor will no longer be overriding unless supported by actual occupation of the land within the respective terms of the schedule. It can be seen from the earlier analysis that there has been some significant changes with regards to overriding interest due to the LRA 2002. However, the changes designed to improve the process are questionable as they introduce further complication to the already complex issue of overriding interest. One of the major areas of complication is paragraph 2 of Schedule 3. The main issue is the meaning of actual occupation. Certain parameters were set by case law under Section 71G of the LRA 1925, but the issue that remained unanswered for a long period of time was whether this continued to apply under the LRA 2002. This point has been addressed directly by the Court of Appeal in the leading case of Link Landing. Under the previous Section 70 subsection 1G, the rights of person in actual occupation are overriding whether or not they are discoverable by a purchaser, while under Schedule 3, the rights of person in actual occupation are excluded from overriding status in two situations. First, where inquiries are made of the right holder and it fails to disclose the rights in circumstances where it could be reasonably expected to do so, and secondly, where the right holder's actual occupation is not obvious on the reasonable careful inspection of the land and the person who might be bound did not have actual knowledge of the interest at the time of the disposition. The next issue will then be whether the rights owner is bound to disclose any of their interest in the property. For example, is it reasonable to expect disclosure when the rights owner knows that the consequences of disclosure would be to lose the family home because the purchaser would take steps to acquire the rights free from the right? This is one of the uncertainties that has defeated the purpose of the provision and can only be settled through litigation. Therefore, this can still be seen as a crack in the mirror principle. Also, there is a question on the meaning of obvious as stated above. It is the actual occupation, not the right, that must be obvious and the reasonable careful inspection of the land. Judges would have to determine what obvious means, as well as what amounts to a reasonable careful inspection, and each case would then have to be determined by its own facts. This appears to me that the schedule will be a reason for many litigations in the future, which means that the Act has not thoroughly dealt with the issue of actual occupation, and there is still a crack in the mirror principle. Although the government through the LRA 2002 have reduced the scope of overriding interest, they still have found it difficult to abolish them all, even though the interest reduces the reliability of the register and goes against the fundamentals of an open registration policy. The Law Commissioner found that some overriding interests, such as the rights of a person in actual occupation, are difficult to abolish because they still need to find a workable solution to suit this age and time. And abolishing such overriding interests would deprive such people of their property rights under Article 1 of the First Protocol of the ECHR. What then can be done to suppress the litigations that are arising from overriding interest? First, there should be active promotion of the advantages of registering overriding interest, as this would benefit the right owners and purchasers, and such interests will lose their overriding status totally. Secondly, the possibility of overreaching should be made available to all purchasers, as all necessary information on overreaching should be made available on the land register. And most importantly, the land registry should now consider it necessary to give honest effect to the mirror principle and require that all interests currently having overriding status should only bind purchasers if they are registered. The responsibility falls on the land registry and the government to amend Section 4 of the LRA 2002 so that it would require all overriding interests currently contained in Schedules 1 and 3 to trigger first registration and only bind purchasers if registered. With this approach, purchasers of land will be provided with a definitive account of the interest burdening that land before the land is acquired, and this will establish a regime of land registration that is suitable for the economic conditions of our time. Finally, it must be emphasized that although the Land Reform 2002 has made a significant improvement with regards to overriding interest when compared to its predecessor, the LRA 1925, it cannot be said that the crack made in the mirror principle by this overriding interest has been totally sealed by the reform. I can therefore say that it is safe to conclude that as long as there are overriding interests, the LRA will never achieve its objective. Thank you.